Hello everyone, I'm Anuj Nakade and you're watching Livelaw. On Friday, the 25th of August, the Supreme Court sought responses from the state government across the country on the status of their compliance with the guidelines issued by the Supreme Court requiring the establishment of district-level nodal officers to curb hate speech. The guidelines were issued by the Supreme Court in 2018 in the Tehseen Poonawalla case. The petition was filed by an activist seeking court's intervention in the increasing incidents of cow vigilantism, and the court had condemned the incidents of mob violence in the country and issued guidelines to prevent the same. Our regular viewers might remember that earlier this month, Nuh in Haryana witnessed communal violence, which eventually spread to Gurugram in the NCR region. In the response of this violence, Vishwa Hindu Parishad and Bajrang Dal organized protest marches throughout the national capital region. Fearing that these rallies will lead to large-scale violence, Shaheen Abdullah filed an interlocutory application in the Supreme Court in a pending writ petition regarding hate speech. This application sought an intervention by the court to stop the rallies. The Supreme Court passed an order allowing the rallies, but also directed the police to make sure no hate speech occurs in these marches. The court also asked the authorities to use CCTV cameras and to make video recordings of the rallies in sensitive areas and preserve all videos and surveillance footage. The court's order reads, and I quote, "We hope and trust that the state governments, including the police authorities, will ensure that there is no hate speech against any community and there is no violence or damage to properties. Wherever required, adequate police force or paramilitary forces will be deployed. Further, authorities including the police will take use of CCTV cameras where installed or make video recordings in all sensitive areas wherever required. The CCTV footage and the videos will be preserved." On the 4th of August, the matter was heard again, and Justice Sanjeev Khanna suggested appropriately sensitizing the police forces to ensure that victims of hate speech could access meaningful remedies without having to come to the court. Less than a week later, the petitioner approached the Supreme Court again with a plea seeking action against calls made by several groups for the social and economic boycott of a specific community after the communal clashes in Nuh and Gurugram. The application also claimed certain groups were even making open calls to kill members of the said community. Yesterday, a bench of Justice Sanjeev Khanna and Justice S.V.N. Bhatti heard this matter again. Advocate Nizam Pasha, appearing for the petitioner, said that the problem is not in lack of guidelines, the problem is that the guidelines are not implemented on the ground. He said, and I quote, "Guidelines are in place. There's an order directing the police to take suo motu cognizance of the instances of hate speech. The only thing missing is the political will to implement the guidelines. What does one do as a petitioner when this court's order is flouted?" The bench, however, maintained that the situation calls for a constructive approach and that pinning blame is not going to help. Justice Khanna's exact words were, and I quote, "This way won't solve the problem because the other side will deny that. We want effective practical steps to be taken to ensure that this court's order is followed." In response to this, Advocate Nizam Pasha said that the most important thing that these proceedings have resulted in was a continuing mandamus. For context, a continuing mandamus is when the court continues to monitor implementation of its judgment or orders in a case by seeking responses and passing subsequent orders. In response to Advocate Pasha, Justice Khanna then assured the advocate that these petitions will not be closed. He said, and I quote, "We are not disposing of the matter. We are not diluting what has been said at all. We are going to reproduce Tehseen Poonawalla directions which are fairly elaborate. We are adding to it, not subtracting anything." Stressing the need of setting the issue of hate speech outside the court had previously contemplated a plan, a committee formed by the district police chief that would access both content and veracity of hate speech complaints and issue appropriate directions to the investigating officer or the chief of jurisdictional police station. This committee would meet within specified timelines when they are apprised of any instance of hate speech and also periodically review the progress in all ongoing cases according to the suggestions floated by the bench. In this hearing, the court had also permitted the petitions to simultaneously approach the nodal police officers appointed in terms of 2018 Tehseen Poonawalla case. Yesterday, the court proposed more suggestions, including increasing the area under CCTV surveillance with a focus on areas where the need is felt. The court said, and I quote, "Additional CCTV cameras should be added wherever the district magistrate or the police commissioner feels is required. This would have to be decided at the DCP level in consultation with the nodal officer. This would be by itself a big deterrent. Apart from this, the court suggested the deployment of police officers in plain clothes in areas or at events where provocative speeches are likely to be made, and for nodal officers to maintain a record of all videos emerging from violence-hit areas, and when the number of complaints exceeds a certain threshold, the committee constituted by the district police chief would be required to examine the material and test if it's authentic. The court also said that the measures to counteract both fake and doctored videos and hateful content will have to be taken away by this committee. After that, the court was informed that the nodal officers in terms of the Tehseen Poonawalla judgment have not been appointed by all states or have not been appointed in all districts of a state. After hearing this, the court asked Additional Solicitor General K.M. Nataraj to take initiative of collecting responses from the state governments with respect to the status of their compliance. The ASG agreed with the court. The court then asked the ASG an order to be passed by the court on this date, and he suggested that the responses from the state should be collected first. At this juncture, Senior Advocate Sanjay Parekh told the court that the Maharashtra unit of the non-profit organization People's Union for Civil Liberties had also prepared suggestions which have been filed with the court. The bench then adjourned the matter and passed an order recording that Home Ministry will acquire information from the state governments about the appointment of nodal officers. The court also instructed the standing and nominated councils of the state governments to be instructed from the state and appear in court on the next date of hearing if the status report is not provided by the state. The court also said in its order that it is welcoming suggestions on the issue from the state governments. The court will analyze and consider suggestions filed by all parties on the next date of hearing, and the suggestions that have been already made with the court were provided to the councils. What do you think of the court's approach to solving the problem of hate speech? Please let us know in the comments below. If you found the video informative, please leave a like and consider supporting the work we do here by joining our channel as a member for only ₹89 per month. Don't forget to subscribe to our channel and hit the bell icon for notifications. Thank you.